Good evening to the participants of the JCJ 2023, that which is going to be held on 7th January 2023 if it is not postponed. Yes, participant, anyone can unmute and read what I posted on the screen. Anyone can unmute and read what I posted on the screen. Participants, anyone can unmute and read what I posted on the screen.
Sir, good evening.
Good evening.
To the AP JCJ 2003 online class 13-12-2022. Law of evidence, Professor Dr. Mohammed Hussain.
Thank you very much that at least somebody read it so that it gives the sense that I am with you and you are with me and both are traveling in the same boat to reach to the destination. Okay, let us come to our point. Andhra Pradesh Junior Civil Judge 2023 screening test to be held on 7th January 2023. The Law of Evidence Act, that multiple choice questions, and 13-12-2022. Of course, timings also given over there. Then first question, be ready. The evidence law is regarded as the dash which directs and assists the court in reaching a decision when dealing with a particular case. Option A, civil law. Option B, procedure law. Option C, forum law. Option D, substantial law.
B, sir.
Yes?
Option
Answer
B.
is? Answer is?
Option B, sir.
What is the answer? See, I gave the four options. A, civil law. B, procedure law. C, forum law. D, substantial law.
Option D, sir.
Wrong. Second option.
Option B, sir.
Second option, what is that?
Procedural law.
Wrong. Third option. Third option. Okay, I will give the answer because I read it today. It is said that it is a forum law. Of course, in other words, we can say it's a adjunctive law also because it's the combination of the procedure law and substantial law. But in the option I have not given. In the option I have not given. When the option I have not given, you are not supposed to assume and presume. What is there in the option, you have to pick it out. So here, the appropriate is C. There is a forum law. And that, if you want, this is the link where I found this point. From that link, I found this point, and that's why I would like to open the link to show you exactly what I want to show. But it is not what I say running. Yeah, I am trying to open it, but it's not running. But anyway, that is the forum law is the right answer for the question. Is it clear? Say yes.
Yes, sir.
Good. Second question. In the case of Dash, it is a 1980 case. The essential premise that sets the evidence law in action was stated. The law of evidence is the legislation that does not impact the substantial rights of the parties but rather strives to facilitate justice for them. So this was observed in the case of which case law? Option A, Ramjas versus Surendranath. Option B, Ali Hassan, deceased by LR, legal representative versus Matiullah, deceased by LR. And C, Manzoor Ali and others versus Qismat Ali and others. D, Kedar and others versus Gobari. In which case law it is decided?
Option A.
Yeah, it is a Ram Jas Surendranath case law. Actually, it is decided. What is the premise that sets the evidence? Law in action was stated. The law of evidence is the legislation that does not impact the substantial right of the parties, but rather strives to facilitate justice for them. So that was the observed in that case law. Okay, next case law is, next question is, third question. The law of evidence is fundamentally a dash, but in certain parts it acts as a dash as well. And option A, substantial law and procedure law, two dashes. B, procedure law and adjunctive law. C, adjunctive law and substantial law. D, procedure law and substantial law. Which one is the right answer? Sequence A, B, C, D. Shoot anyone.
A, sir. A.
WRONG.
B, sir.
Second option.
D, sir. D.
When you are giving answer, you have to read the full. Say again. You have to say in this fashion. Option D is the right answer. Option D, procedure law and substantial law, respectively. So the law of evidence is fundamentally a procedure law, but in certain parts it acts as a substantial law as well. But the both we can say it is a adjunctive law. Or not adjunctive law, adjective law. When you want to say both. Okay, now fourth question. See, you have to pick out what is there in the option. Don't assume and presume it. Which is the appropriate, then only you have to pick out. And the fourth question. Which statement is a false statement? Option A. The word unproved is akin to false. B. What is disproved may normally be taken to be false thing. And C. What if a fact is said to be the disproved, a person arrives at firm and fixed decision after considering the matter before it. D. Option. On the other hand, a fact that is not proven may be true or false. Among this A, B, C, D, which one is the false statement? And 3 are visible and 4 are visible to you.
So
Participants.
Option A.
Suppose if I say option A is a false, why it is false? Can you tell me? You have to give the answer also. Then only I know that, okay, you know it full better. There is no word unproved. The word disproved is there. There is no word unproved. The word disprove is akin to a false. This is the which I highlighted here. The word disprove is akin to false. There is no unproved, but rest of all the things are right. Is it clear? Say yes.
Okay.
Good. Anyone can unmute and read the fifth question?
When one person has, by his declaration, act or omission, intentionally caused or permitted another person to believe a thing to be true or to act upon such belief, neither he or his representative shall be allowed in any suit or proceeding between himself and such a person or his representative to deny the truth of the thing is called or known as.
Option A, accomplice. Option B, adjudicator. Option C, estoppel. Option D, refreshing memory. What is that explanation all deals about among the four options?
Option C.
Option C, it is estoppel. That is nothing but doctrine of estoppel. Why you are taking that much time to understand? It is very easy to make it out. Sixth question. Anyone can unmute and read sixth question? Anyone can unmute and read the sixth question?
It is one of the most powerful types of evidence as the court need not make any inference because this evidence shows the direct impact and has great value to establish or prove any fact in issue is
Dash.
answer A. Answer A.
Option A, corroborative evidence. Option B, hearsay evidence. Option C, direct evidence. Option D, Minerva injunction.
Option C. Direct evidence.
C, sir.
It is a direct evidence. That is the right answer for the question. Seventh question. The four types of the evidence recognized by the courts include A, constructive, B, real, C, testimonial, D, documentary. Now
D.
here,
Documentary.
Documentary. D, sir.
the four types of evidence is recognized by the court and include which one is false among them?
A,
What
sir.
is false?
A, sir. Constructive evidence. Please, sir.
Constructive evidence, there is no constructive evidence. It is a demonstrative, but not constructive. Is it clear? So that is the answer for the question. Eighth question. Indian Evidence Act 1872 has dash chapters and dash sections and came into force dash September 1872. So there are three dashes are there. Option A, 11-167 second. Option B, 10-167 first. Option C, 11-166 second. Option D, 11-167 first.
Option D,
Option
sir.
D.
11-167.
11-167 first.
Yes, you are right. Option D is the right answer. That is, there are 11 chapters and 167 sections, and it is came into force on 1st September 1872. Supplementary question. Law of Evidence Act number.
1 of 1872, sir.
Yes, just one is enough because Act number 1, of course, here it is clearly given 1872. So Act number 1 it is. Okay, supplementary question. Who is the father of the law of evidence?
Sir, James Stephen, sir.
Yes. That's why I did not ask you that question here because everybody knows. Okay, now let us come to the point. Ninth question. Match the following from part A terms with their relevant sections in the law of evidence from part B. Part A. Number 1, confessions. Number 2, character relevance in the criminal cases. Number 3, dying declaration. Number 4, expert opinion. In the side of the part B, A, section 32, class 1, subsection 11, B, 45 to 51, C, section 29, and D, section 54. Now you can match it. 1B, 2C, 3D, 4A. Option B, 1C, 2D, 3B, 4C. Option C, 1D, 2B, 3C, 4A. Option D, 1C, 2D, 3A, 4B. and which is the right
Option D.
Option D, sir.
Option D.
1C, 2D, 3A, 4B.
I appreciate. Good, Lavanya and Shaja, that you gave the good answer for that one. And the confessions deals with the section 29. Character relevance in the criminal case is section 54. Dying declaration is section 32, subsection 11. And expert opinion runs from section 45 to 51 of the Law of Evidence 1872. Yes, now let us go to the point of the 10th question. Which statement is true among the four here I have given? Number one, the general evidence of the good character of the accused is always irrelevant. Two, this is not so with regard to general evidence of the bad character. Three, in a criminal proceedings, the fact that the accused person has a bad character is irrelevant and can't be proved. So options here are given. A, 1, option B, 1 plus 2, option C, 2 plus 3, option D, 1 plus 2 plus 3. So here the three statements are given.
Option C, 2 plus 3.
Option C is the right answer, 2 plus 3. The matter is, the general evidence of the good character of the accused is always relevant, not irrelevant. So, the general evidence of the good character of the accused is always relevant, but I put irrelevant there. So, that is negative. It is not the appropriate right answer. So, right answer are only 2 and 3 statements only. Is it clear? Say yes.
Yes, sir.
Good. 11th question. A dash shall be held to have been made involuntarily if the court believes that it was induced by threat, promise, or other prejudice held out by the police officer to whom it was made, or any member of the police force, or any other person in authority. And what is this term is called? Option A, admission. Option B, confession. Option C, apprehension. Option D, estoppel.
Option B,
sir.
confession.
Confession.
Repeat.
B,
Option
confession,
B,
sir.
confession.
Option B, it is a confession. A confession shall be held to have been made involuntarily if the court believes that it was induced by the threat, promise, or other prejudice held out by the police officer to whom it was made, or any member of the police force, or any other person in authority. Confession, supplementary question. Confession made to the police officer is admissible?
No, sir. Irrelevant, sir.
No, not admissible.
Which section says?
25, section 25.
To whom it will be admissible?
Magistrate.
Any section says?
25, sir. 5, sir.
Again, say
25, sir.
25.
25 confessions to police officer.
Custody, akkade
It runs with the both.
In presence
Yes,
of
sir.
magistrate, it is admissible.
Okay.
It is also included 25 section, sir.
Okay. Means it consisting of the two parts. One is admissibility of the magistrate, and another is not admissibility towards the against the or in front of the police officer. Okay. 12th question. Anyone can unmute and read? I said unmute and read the 12th question.
Dash of Evidence Act states that the word dash includes disposition along with the reputation of a person. Disposition has been defined as what a person actually is, that is, all the acquired
and inherited traits that sum of a person's individuality. Option A, section 55 and character. Option B, section 54 and character. Option C, section 55 conduct. Option D, section 54 conduct.
Option B, section 54 character.
WRONG.
Option A, sir, section 55 character.
It is true. It is option A, section 55, and the next dash is characters. Can you tell me one proverb regarding the character? Proverb, English proverb. Though it is not a part of your JCJ, just I want to check your IQ. If money is lost, nothing is lost. If health is lost, something is lost. If character is lost, everything is lost. Have you heard any time?
Okay.
Have you heard any time?
Yes, sir.
Good, good. I appreciate. 13th question. The fact that any person was born during the continuation of a valid marriage between his mother and any man, or within 280 days after its dissolution, the mother remaining unmarried, shall be conclusive proof that he is the legitimate son of that man, unless it can be shown that the parties to the dash is given the section dash of Evidence Act. Of course, it is given in the section dash of Evidence Act. In which section this runs? Is it 111? Is it 112? Is it 113? Is it 114?
112, sir. B, sir.
B, 112.
It is 112. That is the B is the right answer. What is the right answer?
Option B,
112, sir.
112.
Right answer here. So that is the thing which I want to make it out. Then 14th question. Can anyone unmute and read 14th question?
The case rose due to a contract between the appellant and the respondent. In the beginning, the appellant husband ran a business of stationery named Dash Brother. He died
Untimely.
untimely in 1962. After his death, the appellant carried out the business for a while, and when she could not lead the life of a businesswoman, she decided to allow the respondent to run the business for some time.
And what is case law? This is decided. Number one, Investors Compensation Scheme versus West Bromwich Building Society. 2. Rohitas Kumar versus Om Prakash Sharma. C. Mangala Woman Karandkar versus Prakash Damodar Ranade. And here A 1, B 1 plus 2, C 1 plus 3, D 3. Which is the
C 1 plus 3.
WRONG?
A1, sir.
WRONG.
D, sir. D.
It is a D. Answer is Mangala woman Karandikar is a dead and later legal representatives versus Prakash Damodar Ranade. It is decided the case law. And the 15th case law. In the case of Dash, 1996, the Bombay High Court considered the condition in which independent evidence is not available for the court to proceed with the accused conviction. Here you have the options. A. In which case law it is decided? Roop Kumar versus Mohan Tedani. B. Vishwanath Bahadur Chavan and Menjoy Mastan Chavan. C. Bhimsha Subanna Pawar versus State of Maharashtra. And D. Kalyan Kumar Gagoi versus Ashutosh Agnihotri and another. In which case law this is decided? See, sometimes they ask the question also in this manner. Either the classical case law or the landmark case law or the latest case law. And these are the latest cases which I have made here. Here, the right answer is Bhimsha Subanna Pawar versus State of Maharashtra. That is the case law where it is decided in that manner. Now, here I have given the recent landmark cases under the Evidence Act. So these are the cases which actually I took it from here. This is the law of evidence. See, Mangala woman Kandikar versus TR and Prakash Damodar Ranade. And where a woman has closed the business given to somebody else, but later on she wants to make it out and he did not give it. Again, she filed a case and got it. That is the case law here. And the same thing which I made in the short is, of course, this I did not make it out. But Arjun Pandit Rao Kotkar versus Kailash Kushan Rao Gornian Gontial and others. This is also a latest case law, and where the High Court established a friendly relationship between the Information Technology Act 2000 and the Indian Evidence Act of 1872, holding that Section 65 capital B of the latter as a complete code in and of itself, and that the former legislation and the statutory provision of the Evidence Act as a legal machinery against technological overpowering. So that is connected to both the Information Technology Act of 2000 and the Indian Evidence Act of 1872 regarding the Section 65B, Arjun Pandit Rao Kotkar versus Kailash Kushan Rao Goranchial and others. Then another important case law we will come across is Anwar PV versus PK Bashir and others. And it is a today's technology-driven world. In case of the Anwar PK Bashir case law is significant because Supreme Court decided on the admissibility of the electronic evidence in the court of law. Before, there was no such an admissibility of the electronic evidence in the court of law, but because of this Anwar PV versus PV Bashir, based on the Section 65B of the Indian Evidence Act 1872, they allowed it. So, of course, in the earlier case law, they reversed the judgment. That is the State of NCT of Delhi versus Navjot Sandhu, also known as the Parliamentary Attack Case Law. It is the Parliamentary Attack Case Law by interpreting the application of the Section 63, 65 and 63, 5B of the Act of 1872. So, when the pandemic was there, now they are taking the admissibility of the evidence because of the pandemic. Are you following me?
Yes, sir.
Yes, another case law is Dr. Sunil Clifford Daniel versus the State of Punjab case law. And this case law says about the Supreme Court of India considered the interplay between the Section 162, subsection 1 of the Code of Criminal Procedure 1973 and Section 27 of the Indian Evidence Act. This is the interplay between the two sections. It is very much clear in the Sunil Clifford Daniel case law. A statement made by any person to a police officer in the course of an investigation done, if reduced in writing, but be not signed by the person making it, according to Section 162, subsection 1 of the Criminal Procedure Code is concerned, which makes it clear that the statement made before the investigating officer must not be signed by the witness giving it. He need not to sign. So another section, it says clearly also the Section 27 of the Evidence Act. So that says that it is not applied to the statement made under the Section 27 of the Evidence Act. Which statement? The provision of the Section 162, subsection 1 of the CRPC will not apply to the statement made under the Section 27 of the Evidence Act. So that is made it very much clear by the Supreme Court in the Dr. Sunil Clifford Daniel versus State of Punjab. And then is the Kalyan Kumar Gagoi versus Autosh Agnihotri and others. This is also a landmark case law where it is the Supreme Court of India noted the reason why hearsay evidence is not considered significant under the Indian Evidence Act 1872. So this case law say about the hearsay evidence. What is the section about the hearsay evidence in the law of evidence? Participants? Supplementary question. Whether the hearsay evidence is admissible?
No, sir.
No, sir.
It is inadmissible unless until there is no direct evidence is there, it will be uncorroboratively can be considered. So according to the basics of the evidence law, hearsay testimony is inadmissible in a court of law since in its imprecise and unclear by its very nature. So it is not admissible. Of course, they have given the 1 or 2, 3, 4 points are there regarding the hearsay evidence. And one of the points says hearsay evidence dilutes the truth that needs to be given in court, wasting both the court's and the other party's time. And the fourth point is, they say if the courts allow the hearsay testimony, it opens the door to fraud, misrepresentation, undue influence, and all which unjust to the person against whom the evidence is presented. And that is the reason hearsay evidence is not admissible, or in other words, inadmissible. Please don't give the secret to any woman or a lady. If you say a secret to a woman or a lady, it becomes an open secret. Am I right? Sir, wrong, sir. The story says, if you say a secret to a woman, and if you add one more statement, please don't reveal to anybody. If you say this statement to her, and she will be perplexed and uncomfortable, and unless until we vomit to somebody else, he will not keep quiet. So even the BBC or CNN or Al Jazeera will pass a late news, but this will pass immediately the news. If you add the statement, please don't reveal to anybody because I am saying to you. Is it clear? Is it clear? Sir, I don't know. Say, I don't know. Okay, another case law, Roop Kumar versus Mohan Thedani case law. And this case law is an important case law. It concerns the scope and application of the section 91, 92 of the Indian Evidence Act 1872 as explained by the Supreme Court of India in the following points. So it says 91, 92. Depending upon that, this Roop Kumar versus Mohan Thedani case law decided one of the point, I will read it, section 92 is a similar to the section 91 in that it prohibits the identification of the oral evidence for the purpose of altering the contract, but the former varies from the later due to the limitation imposed by the section 92, which is wholly absent in the case of section 91. So they will make the distinction in the 91, 92 of the Evidence Act, and they emphasized the Supreme Court on this point. Section 91 applies to both the bilateral and unilateral documents, but section 92 exclusively applies to the bilateral document. What is meant by bilateral document? Any idea? If you know it, you tell me. If you don't know it, say pass on. Participants, are you there?
Yes, sir. Pass on, sir.
Bi means two. Bi-monthly, bilateral treaties, unilateral treaties means uni means one. What is the law of contract case law? It is a very classical case law. We can say it is a unilateral case law. Can anyone tell me? Unilateral contract case law. It's a very classical case law. If you don't know, you say pass on. Don't waste my time. Participants,
Awesome, sir.
what did you say? Pass on.
Awesome, sir. Awesome.
What is the case law?
Nehru Bibi versus Dharmadas Ghosh.
That is a case law regarding a contract with the minor is ab initio is void. Mohri Bibi versus Dharmadas Ghosh. But unilateral contract is different. Can I give the name of the case law? Can I give the facts of the case law? Which one you want? Sir, I want both.
Name of the case law, sir.
Carlyle versus Carbolic Smoke Balls Company Limited. That is a unilateral case law. The smoke ball company advertised in the newspaper, whoever uses this carbolic balls and his influenza would be completed or stopped within two weeks. And with that, we are keeping the 100 pounds in the Imperial Bank. That gives a sense it is not a puff, it is not a false statement, and we have the intention to create the legal relationship, and hence it is a binding contract, even though it is from one side only. And hence we can say it is a unilateral contract. Is it clear?
Yes, sir.
One side contract is, there is no other party. Other party comes at that instance only when he consumes or uses the carbolic smoke balls for stopping the treatment of the influenza. What is influenza? Say, pass on. What is influenza? Say, I don't know. Or give me the answer. You have to speak. You have to speak.
Sir, pass on.
Why you are taking so much time? When you don't know, you can say pass on. So that is the we are discussing about that bilateral contract and unilateral contract. And influenza is nothing but common cold. Cold, C-O-L-D, cold, sardi in Urdu. In Telugu, Parisham.
Jalubu.
Jalubu, Parisham. Okay, you do whatever you like. Oh, both Raj versus both and others versus state of Jammu and Kashmir. This is also a landmark case law which the Supreme Court of India pointed out that in the case law it is made very much clear that section 27 of the Indian Evidence Act 1972, which deals with the how much of information received from the accused may be proved. How much the information received from the accused must be proved is nothing more than a proviso to section 25 and 26 of the Act of 2002. A question before the Supreme Court in this case was whether the weapon used in the assault, which was discovered on the basis of information provided by the accused in detention, was sufficient to establish the accused guilt or not. So that is the decided in this case law, and how much it will be proved, and where the Supreme Court has made some 1, 2, 3, 4, 5 bullet points. At least I read the last 2 bullets. The recovery of the object of the finding of the fact as described in the section 27 are 2 distinct things. And the last bullet point is the nature of the fact revealed regard such information determines how much information provided by the accused will be admissible before a court of law under section 27. And this section we already dealt it, this case law, that is the Bhimsa Subanna Power versus State of Maharashtra. In the case of this Bhimsa Subanna Pawar versus State of Maharashtra 1996 case law, the Bombay High Court considered the conditions in which independent evidence is not available for the court to proceed with the accused convictions. And in this case, Honorable Court has concluded that the lack of independent evidence, the court must carefully evaluate the evidence provided by the police witnesses, which, if determined to be the reliable source, will serve as the basis for the accused conviction. If the police has made a certain statement over there which are very much relevant and there is no other evidence would be there, at that instance, police evidence could be taken as a consideration to make the accused be convicted. So thus, where the assault weapon were located in the accordance with the accused statement and no evidence existed that would demonstrate the police inspector's enmity towards the accused, and it would be justified and safe to believe the inspector's uncorroborated statement in regard to the weapon discovered. So that is the about the how much the accused will be convicted based on the evidences produced by the police officer. So these are the Bhimsha Subanna Power versus State of Maharashtra, and these cases are relevantly the landmark cases, and hence at least 3 cases I dealt it. The rest of the cases I covered just now, and you have to see the landmark cases also before you are proceeding to the examination. A case law and what it deals about it, and which section deals about it, and that is very important factor. Yes, and still we have some time with us to discuss. And I already told you that, and the tomorrow also there is a law of evidence is there. So the tomorrow also we'll cover it. But meanwhile, what I want to show you is yes, and timings I already shown to you. The timings are different from one place from days to day. And then next point which I want to impress on you is that. I told you that there are many law of evidence, multiple choice questions are there, which I dealt it earlier. Because I told you, either All India Bar Examination Cohort 15, it is also the same multiple choice questions. And I dealt 15th cohort, 16th cohort 2 times. At least you could find in the YouTube my video clips nearly 100. So in 100, at least you can listen some of them which are very easy, but still they may ask the question from there also. So some of them that you can go through it, but whatever I prepared today, and there is a less possibility would be there, it will be the repetition. Except here one or two places may be there, but it is the repetition. But what I impressed is there, you should be the must, one should have to know it, the core multiple choice questions, one should have to know it. Like we discussed the father of the law of evidence and the act number and the year, when it is effective, what are the chapters and how many sections are there. These are all the basic things one should have to know it. And in addition to that, the important sections, we should have to remember it in your memory, and it is a tip of our tongue. Like 112 we discussed just before. 112. What is the 112 we discussed?
Conclusive proof of legitimacy of
Legitimacy of the 280 days would be there when you can say the is a legitimate child. And that is the, so certain points like estoppel also we did it. And dying declaration also we did it. And confessions we did it. And expert opinions also we did it. So certain sections are very much important. One should have to supposed to know it and its content also. And in that connection, we have to also know that what are the classical case law dealing with this particular section. And especially the Supreme Court cases, you have to refer it. Because once the Supreme Court has given the judgment, again, either if you want to, if any person will be aggrieved by the judgment of the Supreme Court, if the single bed judgment is given, they can approach for the either review or revision or to the division bench or the full bench also, if the matter is so much important. Jai Hind.